Hello viewers, warm greetings of the day. I am Dr. Sharanjeet, Professor of Law at the Rajiv Gandhi National University of Law. Today we shall be discussing the retention vis-à-vis abolition of the death penalty in India. As we all know, punishment is an important aspect of the criminal justice administration. The punishments can range from a fine to simple imprisonment, rigorous imprisonment, life imprisonment, and in the rarest of rare cases, the death sentence. Keeping in mind the irrevocable nature of the death sentence, it has been abolished in several countries around the world. Moreover, it is also felt that the punishment of death does not fit into the current reformative approach towards the criminals. One debatable aspect regarding penology is capital punishment, that is, the justified death of the wrongdoer after following the due process of the law and giving him or her a fair trial and a fair opportunity to defend oneself. The death penalty or capital punishment has been in existence since ancient times in different penal systems across the world, like India, ancient Rome, Greece, England, Italy, and France, to name a few countries. It was justified on the ground of preventing a miscarriage of justice, as it was considered that if a man, without any justification, kills another, he too will lose his life. In many countries during the 17th and 18th centuries, death became the appointed punishment for an ever-widening range of offences, varying enormously in their gravity. As the British expanded their rule in different parts of the world, capital punishment also got legal sanction in different colonies of the British Empire. Those who did not support the death sentence found support in the writings of European theorists like Montesquieu, Voltaire, Bentham, John Sellers, and John Howard. However, it was Cecilia Beccaria's 1767 essay on crime and capital punishment that had a strong impact throughout the world. In this essay, Beccaria theorized that there was no justification for the state taking of lives. In the Indian context, the death sentence has been retained for serious offences that reflect utter depravity on the part of the criminal. Through the recent amendments to the Indian criminal substantive law, the scope of the death sentence has been further enlarged. Thus, in the present discussion, we shall ponder the different perspectives regarding the retention or abolition of the death sentence. At the outset, we shall discuss the various arguments put forward for the retention of the death penalty in the criminal justice system. To start with, deterrence. There is no denying the fact that certain crimes are committed in the most heinous manner, reflecting bestiality and utmost depravity. It is popularly felt that such offenders do not deserve any sympathy. The death penalty serves as a deterrent and also has a retributive aspect, as the victim may not settle for anything less than a death sentence. Here, it is significant to mention the case of Shivaji versus State of Maharashtra, which dealt with the rape and murder of a minor. A death sentence was awarded to a teacher for raping and murdering a 5th grade girl. The Supreme Court said, undue sympathy to impose an inadequate sentence would do more harm to the justice system and undermine public law. The proportion between crime and punishment is a goal respected in principle, and in spite of errant notions, it remains a strong influence in the determination of sentences. Heinous crimes, especially crimes against women, require the courts to impose strict punishment. As observed by Shri Govind Ballabh Pant, Rajya Sabha debates, 1958, if the death sentence is removed, the fear that comes in the way of people committing murders will be removed. Do we want more murders in our country, or do we want less of them? He further said, all sentences are awarded for the security and protection of the society, so that every individual, so far as it is possible, may live in peace. Taking a realistic view, so long as the society does not become more refined, the death sentence has to be retained. Now coming to the second aspect, that is, death sentence is suitable for the hardcore criminals. Viewers, it is felt that certain hardcore criminals are beyond reformation. Any effort to reform them may be counterproductive. If such habitual criminals are sentenced to imprisonment, they may radicalize other inmates. Furthermore, the safety of the prison staff and the general public from dangerous prisoners is needed. Here, I would make a mention of the 35th report of the Law Commission of India. In this pertinent report, this aspect was taken up, and it was recommended that in the present Indian context, the death penalty cannot be abolished. The Law Commission observed, having regard, however, to the conditions in India, to the variety of the social upbringing of its people, to the disparity in the level of morality and education in the country, to the vastness of its area, to the diversity of its population, and to the paramount need for maintaining law and order. At the present juncture, India cannot risk the experiment of abolition of the capital punishment. Dear viewers, the third reason given for retention is with regards to the terrorism-related offences. As we all know, the anti-terror laws in India provide for the death penalty in a large number of cases. In Devinder Pal Singh versus State of NCT Delhi and another, dismissing the accused appeal and confirming the death sentence, the Supreme Court held terrorists who are sometimes described as the death merchants have no respect for human life. Innocent people lose their lives because of their mindless killing. Any compassion for such persons would frustrate the purpose of the Terrorist and Disruptive Activities Act and would amount to misplaced and unwarranted sympathy. Furthermore, in the landmark judgment of Muhammad Ajmal Muhammad Amir Kasab versus State of Maharashtra, the court held that the terrorist attack on Mumbai was aimed at India and the Indians. People were killed only because they were Indians or foreign nationals on the Indian soil. It was to embarrass India, hit its financial center, give rise to communal tension, and create internal strife and insurgency. The attack was nothing short of waging war. Irrespective of the fact that the accused was involved in the attack at only one location, his conviction for waging war was justified and consequently he was executed. Coming to the next reason cited for retaining the death sentence, the serious and violent crimes shake the public consciousness. There are instances of cold-blooded murders in which the perpetrator extinguishes the lives of many people, sometimes the entire family. It is felt that such murderers do not deserve the sympathy of the law and they deserve execution. More recently, under the Indian Penal Code 1860, death punishment has been introduced under Section 376 DB that deals with punishment for gang rape on a woman under 12 years of age. Furthermore, public opinion is substantially in favor of capital punishment, and it is considered unwise to abolish it, contrary to the wishes of the majority of the citizens. Next, we shall be discussing the rationale with regards to balancing of conflicting interests. Dear viewers, one who seeks justice must come with clean hands. A person convicted of brutal crimes has to be appropriately punished. Otherwise, the victim and the society lose hope in the justice delivery mechanism. Social solidarity is also achieved by way of legal vengeance. As every coin has two sides, the flip side demonstrates how the death penalty as a mode of punishment is inhumane, irrevocable, and lacks the deterrence. It is felt that death penalty is a direct blow to the reformative approach. Once executed, the death penalty becomes irrevocable and the chances of reforming the offender are completely lost. Many times, murder or violent crimes are committed due to impulsiveness and the heat of passion, and awarding death sentence to such offenders is often criticized. Here, it is pertinent to take note of the dissenting judgment of Justice P.N. Bhagwati in Bachan Singh versus State of Punjab. The death penalty is qualitatively different from a sentence of imprisonment. It is irrevocable and beyond recall. Therefore, conferment of an unfettered, standardless, and unguided discretion upon the court under Section 302 of the Indian Penal Code, read with Section 354, subsection 3 of the Code of Criminal Procedure, to choose between life and death by providing a totally vague and ad hoc criteria of special reasons, renders the death sentence for murder arbitrary and unreasonable, and hence in violation of Articles 14 and 21 of the Constitution of the country. The second reason is delayed execution. Dear viewers, in the Indian Criminal Justice Administration, the prisoner who has been awarded a sentence of death may take recourse to appeals, mercy petitions, and pardoning powers vested with the executive. The criminal procedural law also contains specific provisions regarding commutation and remission of sentences. Thus, the execution of the death sentence is most often delayed. It is felt that the death sentence involves an inevitable element of suffering and humiliation, especially in those cases where the delay occurs in the execution of the death penalty. The sentenced person's mental anguish of anticipating the violence that is to be inflicted upon him is considered cruel and inhuman, and therefore it is said to be a violation of the human rights, the right to life and the right not to be subjected to cruel, inhuman or degrading treatment. Dear viewers, with regards to this debate, we shall also consider the specific circumstances of the offender. A death sentence is awarded for heinous crimes like murder. It is important to note that a murder may be committed on account of several factors and circumstances like intoxication, instigation, abetment, hatred, jealousy, poverty, rejection of a love or marriage proposal, sexual frustration, revenge, etc. Thus, even though the crime committed is a direct infringement on the right to life of the victim and his or her family members, the offender may still have the possibility of reformation, and executing him or her may not serve any useful purpose. On the contrary, it may cause unwanted miseries to his immediate family and dependents. Death penalty is also criticized because of the wide discretionary powers given to the judges in this regard. Marcus de Lafayette had said, "I shall ask for the abolition of the death penalty until I have the infallibility of human judgment demonstrated to me." The Evans case in England, in which an innocent man was hanged in 1949, played a large role in the abolition of capital punishment in that country. However careful the judicial process may be, it is impossible to eliminate the chances of judicial error. What is the guarantee, therefore, that the evidence relied upon is truthful? So this is a very, very important question that we all need to ask ourselves, that whether the evidence was truthful enough to execute a person. Death sentence is also alleged to be discriminatory. According to Justice P.N. Bhagwati, the death penalty in its actual operation is discriminatory, for it strikes mostly against the poor and the deprived sections of the community, and the rich and affluent usually escape from its clutches. In the case of Murli Manohar Mishra versus State of Karnataka, the Supreme Court took note of disparity in the award of death sentences in different cases and rightly observed, the question of death sentence is not free from the subjective elements, and the confirmation of death sentences or their commutation by the court depends a good deal on the personal perception of the judges constituting the bench. On the one hand, there appears to be a small band of cases in which the murder convict is sent to the gallows on confirmation of his death by the apex court. On the other hand, there is a much wider area of cases in which the offender committing murder of a similar or far more revolting kind is spared his life due to the lack of consistency by the court in giving punishments, or worse, the offender is allowed to slip away unpunished on account of the criminal justice system. Next is the delayed exercise of the pardoning power by the President of India. As we all know, Article 72 of the Constitution empowers the President of India to grant pardon and to suspend, remit or commute sentences in certain cases to the convicts. Similar powers are given to the governor of a state under Article 161. Even though the purpose of Article 72 and 161 was to correct judicial errors and save the convict from the consequences of a harsh punishment adjudged inadvertently, the ground reality remains that many times the application for pardon by a convict on death row is not entertained promptly, thus causing mental anguish to the prisoner and his family. On death row for the past several years, Muhammad Afzal wanted a speedy conclusion to his ordeal. He said that the cumbersome legal procedures and prolonged period of solitary confinement were cruel and inhuman. Dear viewers, the psychologists call this condition as the death row phenomena, in which the prisoners spending years awaiting their execution go through extreme mental torture, a fact that was also recognized by the European Court of Human Rights in 1989. In the case of Madhu Mehta versus Union of India, the Supreme Court made the following observations. It is well settled now that undue delay in execution of the sentence of death would entitle the condemned person to approach this court, or under Article 32 of the Constitution, But this court would only examine the nature of the delay caused and circumstances that ensued after the sentence was finally confirmed by the judicial process, and will have no jurisdiction to open the conclusions reached by the court while finally maintaining the sentence of death. But the court is entitled and indeed obliged to consider the question of inordinate delay in the light of all the circumstances of the case to decide whether the execution of the sentence should be carried out or should be altered to imprisonment for life. The convict has suffered mental agony from living under the shadow of death for far too long. He should not suffer the agony any longer. In the facts and circumstances of the case, therefore, we direct that the death sentence should not be carried out and the sentence imposed upon him be altered to imprisonment for life. Dear viewers, at this stage it becomes highly imperative to throw some light on the 262 report of the Law Commission of India. In this significant report, the Law Commission of India recommends the abolition of the death penalty for all offences except those related to terrorism. The Law Commission had received a reference from the Supreme Court of India in Santosh Kumar Satish Bhushan versus State of Maharashtra and Shankar Kishan Rao Khade versus State of Maharashtra to study the issue of the death penalty in India. The Law Commission had concluded, after studying the issue extensively, that the death sentence does not serve the penological goal of deterrence any more than life imprisonment. It also pointed out that in focusing on the death penalty as the ultimate measure of justice for victims, the restorative and rehabilitative aspects of justice are lost sight of. Furthermore, the death penalty in India operates within the context of a lack of resources, outdated modes of investigation, an overstretched police force, and poor legal aid. Thus, the administration of capital punishment remains fallible and vulnerable to misapplication. Let us come to the conclusion. Criminal jurisprudence in different parts of the world is vexed by this important issue. A rigid dichotomy exists between the abolitionists and the retentionists. Retention of the death penalty is seen as consummate with the needs of justice and deterrence for the offender and other criminals who commit serious crimes without any remorse. In recent times, the Supreme Court has advocated the three-test theory in deciding death penalty cases. It means that the three tests have to be satisfied before awarding the death sentence. That is, the crime test, meaning the aggravating circumstances of the case. Second, the criminal test, meaning that there should be no mitigating circumstances favoring the accused. And lastly, if both the tests are satisfied, then the rarest of rare test applies. And this depends on the perception of the society and is not judge-centric. That is, whether the society will approve the awarding of a death sentence to certain types of criminals or not. In Kamta Tiwari versus State of MP, the Supreme Court ruled that before opting for the death penalty, the circumstances of the offender also need to be taken into consideration along with the circumstances of the crime. A balance sheet of the aggravating and mitigating circumstances has to be drawn up, and in doing so, the mitigating circumstances have to be accorded full weightage and a just balance has to be struck between the two. Similarly, in Bachittar Singh versus State of Punjab, the Supreme Court observed that there ought to be evidence to show that the convict would be a harm and danger and threat to the harmonious and peaceful coexistence of the society. As discussed previously, capital punishment has been prevalent in almost all parts of the world as a deterrent and retributive form of punishment, although with the passage of time, the methods of execution of the death sentence have been humanized and brutal methods of execution are no longer practiced. In the Indian context, public hanging has also been declared unconstitutional and a violation of the prisoner's rights. With regard to the abolition of the death sentence specifically, in India, there is no denying the fact that the crime rate is increasing, in particular violent crimes and sexual offences against women. Hence, in such a scenario, capital punishment is considered as a necessity. The same holds true with respect to terrorism, as a single act of terrorism can kill and maim hundreds of innocent men, women and children. So, awarding a death sentence to the terrorists is considered justified. Ajmal Kasab, who was executed in the Mumbai 26/11 carnage, had, along with his fellow terrorists, ravaged Mumbai, the financial hub of India, and had no remorse for his heinous act. As the law has to balance the conflicting interests in society, it becomes integral to the criminal justice administration that the judiciary exercises its discretion to award capital punishment after an in-depth evaluation of the case. With this, we come to an end of today's lecture. Thank you very much for patient hearing.